The Supreme Court ruling today comes near the end of the term for the justices and is also one of the most closely watched cases.
The court rejecting affirmative action at colleges, impacting millions in the admissions process, and the ruling came with a strong dissent. CBS 2's Doug Williams here now with the details. Doug.
Maurice and Christine, the Supreme Court this morning overturning a ruling they made back in 2003. That race could have been a factor in the college admissions process. But this morning, the court ruled against years of its own set precedent. The Supreme Court on Thursday ruling that colleges and universities must stop considering race in their admissions process, specifically striking down admissions plans at Harvard and the University of North Carolina, the nation's oldest private and public colleges. Thursday's decision in a Supreme Court with a conservative majority reverses policies the court had upheld as recently as 2016.
The Supreme Court, in this majority opinion, has essentially rejected a lot of the argument and reasoning that has been part of prior precedent, rewriting of the factual and historic record about what courts have said is permissible in the past and what colleges and universities have been saying that they're doing.
Colleges and universities have long been forbidden from using race quotas, meaning target minority percentages in their student bodies. Thursday's decision simply excludes race from being a defining factor in admissions. Students, guidance counselors, and admissions offices are left to decide what can be disclosed and where, something President Biden addressed in his remarks this afternoon.
Let's be clear. Under this new standard, just as was true under the earlier standard, students first have to be qualified applicants. Discrimination still exists in America. Today's decision does not change that. It's a simple fact. If a student had to overcome adversity on their path to education, the college should recognize and value that.
Judge Neil Gorsuch states in the ruling, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise, meaning that students who feel their diverse background is pertinent can discuss it in their application. Andrew Brennan, who was recently accepted to Columbia Law School, sees any restrictions on disclosing race to be near impossible to imagine.
It's very hard to imagine a world where students of color like myself would be able to fully represent ourselves, our qualifications, what we can contribute to campus in a race-blind environment.
And as part of the minority dissent, Justice Sonia Sotomayor writes that, quote, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. Maurice, Christine, back to you.
Doug, thank you.
And the court announcing tomorrow will be the final day of this term. There are 4 cases left to decide. That includes 2 cases challenging the president's student loan forgiveness program, a case deciding if a Colorado website designer can refuse business to same-sex couples, and a case dealing with trademark infringement that occurs outside the United States. We have continuing coverage on our website. We've got the link to the full opinion and the dissent on the affirmative action case. It's all there at cbsnewyork.com.